Welcome to the law offices of Cheryl David. My name is Justin Plummer. I'm one of our attorneys that will be helping guide you through this webinar this evening. My hope is that you learn a little bit more about estate planning, elder care law, and guardianship matters as it might pertain to you or one of your loved ones' estate matters. Here at the law offices of Cheryl David, we have been doing this area of practice specifically for over 38 years and are all board certified in order to handle these affairs and give you a unique perspective to how to better help plan your estate. I feel like the best way for us to get to know one another better is to have you watch a video about our office and how we got started. From there, we'll start diving in deep. And I would ask that you have a pen and paper to jot down some questions or issues that you'd like to chat about. And I'll leave some time for questions and answers at the end of the session. We also have a Q&A feature or a chat feature where you can input those questions during the time. And one of our attorneys or paralegals will be able to formulate or get those questions answered by an attorney to you.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I could lose somebody so dear to me so quickly was devastating. And it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter, Blair, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
Also first met Cheryl through his mother, who came basically to live with us after his father passed away. And so we would try to make it similar when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes. Transfer of the estate took a matter of weeks.
No one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you, and we'll try to come up with the best plan that we possibly can.
All right. I think that was a great introduction, and I'll give you some of my more personal stories as we go along as it pertains to some of the items we talk about. As I love to say, I'm not only the president of this club, I've also been a member for a long time after my dad passed away, and having to deal with some of my own personal planning matters and family planning matters. I like to talk about those experiences as we go through. Again, as I already stated, please jot down any of your comments in the chat feature and the Q&A icons as part of your attention. And for attending this webinar, we are offering you a free Calendly or a free meeting through our Calendly update system, where you'll see a link on your screen, and I'll also input that in the chat feature so you'll have a direct link to it. You can go online and in the next 2 weeks and create your own time frame to meet with us at your leisure, pertaining to the different calendar blocks that you'll see in front of you. And otherwise, if you came in off the street or otherwise without this webinar, that would be a $425 consult fee that we are waiving for you as a gift for you for paying attention and joining us for this webinar. So we hope you take us up on that. And without further ado, let's talk about some estate planning. Now, there's a lot of plans out there in place. There's a lot of non-planning in place. And I feel like the day and age of the internet and some other things, talking to friends, family, colleagues throughout the world, you may get some misinformation or maybe information that's not quite specific to your facts of how it pertains to your life. So I get very hesitant when you hear somebody else going through something. Basically, what you own and how you have things set up have a very big interplay with how those things get controlled or distributed or to your next of kin when you pass away. So your situation might be very different from somebody else's. But as far as planning goes, everybody likes to not have a plan because it's just always the easiest thing to have on your next year's to-do list. It's just something, quite frankly, that is easy to kick the can down the curb on. Nobody likes to talk about death or disability or getting older. And there's a lack of knowledge out there as well. Again, you can find nearly anything on the internet, but be careful out there because a lot of things do not get updated as far as current tax laws are concerned, or just general information may be older or outdated. Again, this is also the area of the law where a lot of different areas combine and come together in the sense, as you might imagine, when somebody passes away, they could have been divorced. They might have been through a bankruptcy. They might have real estate. They might have been on Medicaid. There might be some other judgments against them. They might have been suing someone. So there's a large amount of information issues that can come up where a lot of different areas of the law are combined. And so I think that's why dealing with an estate planner who specializes in this field matters greatly when you are starting about or talking about discussing your plan. So at the end of the day, what you have to ask yourself is what's most valuable to you and what do you want to protect? What are your goals? I always tell people, quite frankly, this is not the fast food world where one size fits all for most people. Some people are on second marriages with stepchildren. Some people don't have children. Some people are single individuals. Some people might want to give their charities funds after they pass away. They might want to leave money for pets, those types of things. Maybe they want to leave it to their grandchildren. So as you can imagine, everybody has different goals, different assets, and different life or fact patterns that can lead one result to another. I feel like the best way to tell you about this is to kind of walk us through what these processes look like without planning documents, if you had no planning documents in place. And often with Bill and Mary Jones, it's always good to see a situation where you can kind of take an individual couple and actually follow their kind of life situation throughout this process so we can see how it affects them personally. Now, Bill and Mary Jones, for our purposes, are going to be a North Carolina couple that's in their 60s, having an estate worth about $700,000 or more between real estate, life insurance, investments, what have you, kind of as a general number for them. In this scenario, John and Susan are Bill and Mary's children, and we'll talk more about them and how they may stand to inherit or different options for them down the road. Now, from a planning standpoint, there's a lot of options for Bill and Mary and all of us. You can spend every last dollar. That never happens. I've seen a lot of people get close, but that's always a greater plan in our minds that actually gets done. You can die intestate. In North Carolina, that means that you can have, if you don't have a plan in place when you pass away, a will, powers of attorney, trust, what have you, The state of North Carolina mandates they have a plan for you. And that might not be the best plan because the state statutes then govern what happens at that point in time, and it takes your options and your choices out of the mix. So passing away without wills or living without powers of attorney is a very dangerous idea, because the way I explain it to people again is, while you are alive and well, North Carolina says that you can create these documents and permission slips, however you think about them, for when and if certain circumstances come up. However, if you don't, and you become incapacitated or pass away without those documents in place, the state of North Carolina's laws kick in, and they are not always what people think or presume will happen. So it's a very dangerous thing to do, is to not have these documents, because you won't be here to tell the court what you meant or what you wanted or intended to happen. That will not matter, quite frankly, at that point in time, because the state laws will then take over. Some people put items in joint tenancy, meaning that they co-own them, maybe with a child or another individual, family member, what have you. There's a lot of these will avoid probate in some situations. However, a lot of times people don't realize that you're actually gifting or giving control or those assets over just as much as they are yours to that individual. I've seen some terrible situations occur over my years where joint titling on assets, especially real estate or something of that nature with a child, may not be the best way to go about it, because they have just as much rights to those assets as you do. And if you have a falling out, or if the child becomes divorced or has creditor issues and stuff, there's some interplay there that can affect you personally. So it's always good to talk to an attorney before you start going about doing those types of things. Excuse me. Within a simple will, a will, as we'll talk about here in a moment, a will goes through court. Now, your will is a game plan for the court, but it still gets to dictate who is in charge when you are no longer here to take care of your final affairs, and who you want to receive your estate. You can also do a trust. A trust is designed, hopefully, to keep you out of the court process when you become incapacitated and when you pass away. Sometimes people do these in a very bare bones way. Other people do it in a more complete way. We'll talk a little bit more about that. Quite frankly, as again, we'll talk about it a little bit more later, you should not have a trust if you do not have your assets connected to your trust. So something to keep in mind there. Now, let's talk about Bill and Mary's situation again. If they have no documents in place, no wills, no powers of attorney over finances, no powers of attorney over healthcare, the idea, and just because simply they are married, will not get around the fact that likely if Bill has a stroke and then becomes incapacitated and cannot handle his legal affairs, his wife will not be able to just swoop in and act on his behalf without some form of a permission slip, or here, guardianship proceeding. Now, guardianship proceedings are meant to take the place of a lack of a power of attorney. And as such, the court then gets to choose who they think the best person to be this person's guardian is going to be, and who should manage their affairs or healthcare decisions going forward for the remainder of their life. I can tell you that I went through this personally with my grandmother in high school. And unfortunately, she did not have a power of attorney and had to go through a guardianship proceeding for my dad to get the permission slips to do business on and make decisions on her behalf. It was a very costly matter. Most of the time, you have to have an attorney, or it's advisable to have an attorney help you with these situations. It is a court setting. There are certain hearings and other requirements that are necessary. And the whole person's health, mental status is laid out in front of court. It's very humiliating for that person. And there's a lot of personal information that's disclosed. And additionally, even if you were to get named as a person's beneficiary, or excuse me, guardian on an account, you still have to, for the remainder of that person's life, every year, create an accounting to the court down to the penny out of how all of their funds are being spent month to month. It can be very expensive, very frustrating when seemingly you're only trying to say, get a permission slip to pay a bill, access an account. So these are the things that are forthcoming if you don't have a plan in place. Now let's talk about probate. This is the word that I get to hear thrown around about quite a bit, and it certainly, for good reason, causes fear in a lot of people. Probate, in North Carolina at least, is the process by which your will, or if you don't have a will, the state laws then dictate who is to receive your inheritance or your assets at your passing. Now, without a will, intestacy mandates that based on who is alive and who was related to you at the time of your passing may be involved in who is to receive your estate. It will all matter on if you had a surviving spouse. Did you have children born of that relationship? Did you have children born out of that relationship? And somewhere in there will be a formula as to how things filter to that next generation or those next people. This is a very convoluted process, even with a will that, or without a will, takes about a year to a year and a half, can be very expensive, and has a lot of moving parts, probably at the worst time for this to happen, because most of your individuals who are acting in this regard are probably related to you or have some sort of grieving time period coming around. One of the most important aspects of this is that you could stand to lose around 2 to 5% or more of your assets going through the probate process. It's very much a mindset of a death by 1,000 cuts, if you will. There's bond fees for the executor to be bonded. There are inventory fees, opening fees. It's $120 to open the estate. A fee of $1, $4 on every $1,000 that comes through the estate is a probate fee that's payable to the court. Further, you have to run notices of creditors in the newspaper, and there are timelines with which it is, it may not be something every day with the court. However, it will be a very involved process for a year to a year and a half. I can also tell you that if you have property in more than one state, if you have a timeshare in South Carolina or Mountain House in Virginia, any items with real estate could cause you to have several of these proceedings after you pass away in different states. I've seen many occasions where there's a probate proceeding here in North Carolina and one in South Carolina and even maybe another state. These things are also public. You can request anybody's probate file under the Freedom of Information Act and see what their different children or other people are inheriting. That's troubling to think about as well. I can tell you from my own experience, this actually is how I got into the area of law that we practice in now. After law school, unfortunately, my father had just retired and he suddenly passed away. And being an only child of two only children, I got to see how difficult it was handling his estate, even with my legal education on behalf of my mom. We had to go through a full probate proceeding when he passed away because my grandmother had left some inherited property that my mom was not connected to or a joint owner on. So we had to take that through probate along with some other smaller assets. So this is a situation where you probably will want to avoid this the first, or if you're married, upon the passing of the second spouse, because again, what drives the need for court involvement or not is going to be how the items are titled: vehicles, real estate, cash accounts, those types of things. Often in a spousal situation, you may not have a probate proceeding at the death of the first spouse, just by the nature of most people who are married or couples are keeping things joint between them or beneficiary driven, something like that. However, we're always concerned with a common passing, maybe in a car accident or something, where it won't be so foreseeable as to how to plan the estate or who's going to go first or second. So it's important to have a plan that hopefully can avoid court altogether, as a mainstay to that. Because if you're talking about those kinds of fees and the headache and the timelines, there's got to be a better way to go about it. So let's talk about death taxes. I get this question quite a bit. In North Carolina, we no longer have an estate tax, which is good. Got rid of that, I think, in 2012. Federally, there is still an estate tax that does not affect many Americans at all. You are only affected by this estate tax if you're single, if you have more than 13.99 million for 2025. And if you're married, if you have more than $27.98 million. That is the only time the federal estate tax laws kick in. There's word that if Congress does not act this year by New Year's Eve of 2025, it could come back down to 5 or 6 million indexed for inflation. So it's something to keep an eye on, but it's not anything day to day that we are concerned with for most of our clients. Now, if you take a look at Bill and Mary's situation where they had no documents at all, had to go through possibly 2 guardianships if both of them became incapacitated down the way, had to go through court twice for probate situations, as well as Mary's cost after Bill passed. If Mary had to stay in a facility or a long-term healthcare facility for anywhere from $7,000 to $11,000 a month, given on a yearly time frame, you can take a look at their assets for how it got spent. However, you need to apply these numbers to your own estate and kind of find that number for yourself. Most of the time, funeral expenses, probate costs, nursing home costs, all those things can combine to be a very, very sizable number. And it's important that you take that into consideration, because most people are very shocked by the numbers that they're seeing for end-of-life care and processes. Again, not everybody's estate's the same. So if you see these numbers, you can kind of compute it to what it would mean to you and your family. As we've already talked about, it's important for you to have your own voice for your own documents while you're alive and well. Again, the state of North Carolina could care less, quite frankly, if you have these documents or not. However, if you pass away or suddenly become incapacitated without them, the only option will be through these processes with the court, which can be very aggravating and expensive. So let's talk about something that's a tool that we use most frequently in our line of work, that we can avoid probate costs and can work a lot of family issues as a workaround for your estate plan. A trust, a revocable trust, is really a shell of you. A trust is something that, if done correctly, will avoid probate at the first and second deaths of spouses, or if you're a single individual at your death, and also help to avoid guardianship matters down the road. The idea being this: a trust is really a will in a contract form. You, while you are alive and well, are still under control of all of your assets. And by connecting those assets to your trust, what you're really doing by taking the real estate, your brokerage, life insurance, taking your investment accounts and connecting them in some way or another to the trust, you are fast forwarding through the probate process while you are alive and well. And from there, your family can totally avoid the court process of probate and guardianships down the road, and make things much easier and simplistic when the time frame comes. Additionally, there's also some terms and conditions that you can place into your trust that can protect your beneficiaries, your children, or whoever else, in cases of divorce, creditor issues, bankruptcies, etc., down the road, so that you can kind of tie a golden bow around your inheritance for your children down the road for things they might not even be thinking about that may come their way after you're gone. Again, the trust is a shell of you. Your taxes will be the same every year if you set up a trust. everything is still following your social security number. So everything is still you. This doesn't give you any creditor protection from if you get sued or anything of that nature while you're alive and well. However, it's meant to be a standby device that when you pass away, the idea is that once a death certificate can be issued, there's no going to court, there's no getting those proper permission slips to the court, any of those items. Whoever you've named in your trust to take over after you are gone can step right in and handle those affairs and distribute out money, pay final expenses, all those things. It's a much easier process down the road for your loved ones, children, whoever you may place in those positions. Again, if there's a trust, and when we do a trust, we also establish it as with everything as a package for your powers of attorney for finance and healthcare and all of your advanced directives, such as a living will, a HIPAA authorization. So you will have the whole package of documents that you need if and when those things come about. The great advantage of using a trust is it's much like a tube of toothpaste. If you were to leave everything to your two children, much like Bill and Mary, if they have two children, they want to split up their estate equally. Each of those children will have their 50%. And the idea, depending on the nature of what's happened to them in their life or what their life situation is, the trust can have some protections wrapped around it so that if they are in the middle of a divorce or something of that nature, that those assets don't immediately go to them. However, they have direct access and can pull from them. So it's kind of like taking a little bit of toothpaste out of a tube at a time versus squishing the toothpaste container and having everything given out to them all at once. That's certainly an option, but for a lot of people, we like to kind of wait and see what their life circumstances look like before we give them the keys to the castle. Those are just some added benefits that we can do with trust planning that are more difficult or impossible to do with will planning. Additionally, our firm does not charge any extra if you have a special needs beneficiary or we need to set up some type of special needs trust. If you or a loved one are on benefits, government benefits, SSI, or receiving Medicaid, it's very important how those individuals inherit money, because if they inherit it directly and are on government benefits, they will be kicked off of their government benefits and lose them. Additionally, depending on how long they've been on those benefits, if there are assets that come in that they receive, if they don't receive them in a certain way legally, then there could be repayment provisions to the state for funds that the state has paid out on their behalf. And no one needs to lose what the money they worked so hard for by giving it to one of their loved ones in an incorrect or an inadvised way. So they lose all of that money and it goes to the state. So our firm does not charge extra for that type of planning. We do it all the time, but it's something to consider if you have those life situations happening to you. So I think we've talked about this quite in depth, but the idea would be, again, if Bill and Mary have a trust and all those proper powers of attorney and documents, they're not going to be going through anything of that first scenario. Quite frankly, if Bill becomes incapacitated, Mary can use those powers of attorney to step in and pay final expenses, make healthcare decisions, etc., and vice versa. Additionally, if Bill passes away, we're not going through court at that point in time for a probate proceeding. If Mary later, after Bill dies, becomes incapacitated, we probably have some issues there drawn in for either both of the children to be able to be named as a power of attorney to act on mom's behalf, or maybe one or the other. Additionally, if Susan was in the middle of a divorce when mom and dad passed away with a trust, her little 50% of the trust is going to be protected from that divorce so that none of that goes to the, surviving soon-to-be ex-son-in-law. If John, God forbid, had a lot of creditors or bankruptcy tax liens or just had been bad with money, or maybe there's a substance abuse issue there or something of that nature, we can build in protections around the trust so that money doesn't flow to him directly, but can be doled out to him over time or in certain ways so that it doesn't go into his pocket and out the other down the road. Of course, there's other situations that can present themselves with minors. You have to be 18 in North Carolina to receive money, and even then, that might not be the best idea. We might need to stagger that, say, at certain intervals, like say 25, 30, or maybe upon college graduation or some other type of event. We do that quite often through trust work. Let me take a second here to talk about something that everybody always asks about, and it's very important, but I need to give you a little context to it first. So our office does estate planning and elder care planning. A lot of people get these things confused. Elder care planning is kind of a smaller subsection of estate planning in the sense that it really deals more when end of life care or debilitating diagnoses come up, and we know that there's a kind of a finality coming before us. And a lot of times what we're trying to do is to safeguard assets so that if your well spouse is at home or still trying to care for their sick spouse, that all of their assets aren't going to be taken away, or that at least down the road we can preserve real estate and other assets from going towards long-term care. These are your options for paying for long-term care expenses if you get a bad diagnosis or have health ailments that necessitate it. You can certainly use your own money. Again, cost of care anywhere is from $7,000 to $11,000 a month, depending on what the need is versus where you want to be, those types of things. Certainly, if you have long-term care insurance, that is a great benefit to have. Some people have it, some people don't. I encourage you to take a look and see if it can fit into your budget, because it certainly is. Prices are not going down, and certainly any kind of cost to frame it can certainly help families along the way. If you're a veteran, there are aid and attendance benefits for qualifying veterans for certain wars and certain time periods and for their spouses. So that's something to consider too. I often hear that, I'm not worried about this, Justin, because Medicare is going to take care of everything. That is so untrue, that a lot of times it starts longer conversations, but Medicare is only going to pay for your first 20 days or so stay in a rehab facility or so. Quite frankly, after that time period, the doctor's probably going to write a form that says that, you need to go home or you need more private care, and that will be on your dime. You don't have to go home, but you can't stay here kind of mentality. And from there, you may have to go into a private pay facility or in-home care, and that's when the money will start flowing out of your pockets. So Medicaid is something that we can get most people qualified for on a long enough time frame, depending on what your assets are. But this is a system that we've all paid into for all of our lives. And if you think about it, if there are ways to protect your real estate, if you had to go into a facility or other assets and still take advantage of some of those laws, you definitely should take a look at doing that. If you go through all of your other money and have to qualify for Medicaid, depending on how long you've been into care, the state Medicaid recovery will have a lien on your home that they can sell when you're gone and recoup the money they paid out on your behalf for. So for many of our clients, your real estate is one of your largest investments, and we can certainly try to safeguard those if these needs arise, but you don't have to sell off everything before you go into a nursing facility in North Carolina. That's why I encourage you, if you or a loved one are going through these things or these are a coming attraction, please talk to an estate planning attorney, because there are no reasons why you have to lose everything to go into end of life care. There are certain rules, conditions around it. However, there are certain loopholes, just like any other tax laws or any other thing, that you certainly can take advantage of. The way I look at it is, when I go get my taxes done every year, I want every legal deduction I can when I go pay my taxes, because why pay more if you don't have to? In that same vein, if you can take advantage of the laws the way they're written and still keep some assets to hand down to loved ones as inheritance, why wouldn't you do that? So I think the important aspect of that is to realize that in 2018, we had a pretty major financial power of attorney, durable power of attorney. You can use those words interchangeably there. We had a law update in 2018, and when our firm took what the state statutes had given us, we revamped our powers of attorney into something called an enhanced power of attorney, so that if and when that time should arise, even if you're already incapacitated, we can work with your named agent or power of attorney to still try to protect or safeguard your home or assets down the road. Your power of attorney is really the best starting spot. But because of the way the laws are situated currently, and because this is more of a finality or knowing that we're closer to passing, it's difficult to say when to start those aspects, but the sooner you can talk with an attorney about it, the better. So my hope is that you've gotten some information that will get the ball rolling for you guys, and for you to maybe take another perspective on your older plans if you already had one in place. It's never a bad time to revisit it, especially if times or life situations have changed. I always tell people this is one of the aspects of our area of the law that it's important, and you pay for what you get. So please avoid bargains, online wills, trust, all those types of things. I could stay here for hours and try to give you every story I had about somebody who tried to do their own plan or try to write up something of their own. And unfortunately, in our world, words matter. And for instance, I had a situation where a husband tried to do his own will, passed away. He meant for everything to go to his spouse, but with the words he used, he actually disinherited her. And tens of thousands of dollars were spent trying to fix something that could have been pretty relatively inexpensive from the outset. So best laid plans of mice and men in that regard. But we believe in flat fees and being transparent with our fees to potential clients. It's always the best medicine. So when we do a trust package, if you are a couple or if you're a single individual, the price is still the same. It's $68.50. What that gets you is us creating the trust, as well as all of your other needed documents, your financial power of attorney with those nursing home protection permission slips built into it, your healthcare power of attorney, your advanced directives for do you want to be on life support, those situations, your HIPAA authorizations, a pour over will, all of these things combined. And the added advantage is that we're probably one of 4 or 5 firms in the state that actually helps you take your assets and make them part of your trust. Again, that is how all of this works. And if you have a trust already that doesn't have all of your assets connected to it, it's probably not worth the paper it's written on. So I highly encourage you to revisit that. We feel like we do this, and when you leave here, we want you to have something that works. And so we're going to help you put all of your assets into our trust. Certainly, that is a cost up front, but that pales in comparison to what your family or loved ones could stand to lose way down the road exponentially. So highly encourage you to think about those things, and when you're considering these things. We include one deed fee within there. Of course, if there's more or additional tracts or different states, we'll have to assess you on those as they go. If the trust package didn't speak to you, and maybe you just want something in place to kind of tide you over while you're thinking about it, or maybe you're early on in planning or life, we certainly still do wills and will packages. Those are separate. You don't need both of these items. It's kind of a pick or choose. But if you want the will portfolio, that's your last will and testament, your financial power of attorney, healthcare power of attorney, advanced directives, HIPAA, and that ends up being $2,100 per person. So if you're a couple, it would be $4,200. But at least that gives you something to have in place for down the road. Whatever you do, please don't put your head in the sand and not think about these things, because your family and loved ones will appreciate it, even if you don't. And once you get it done, you don't have to think about it too much down the road. That's the good news of getting it off your to-do list. Okay. So again, for your time and attention, we're giving you a free consultation with an attorney. Again, a $420 value if you're coming off the street. We just ask that has to be within 2 weeks. And if you are married, both spouses must attend. Let me say that again. Both spouses must attend. Sometimes we have one show up without the other. We need both of you there. And finally, are we going to work together? A no is fine. Yes, that's great too. The only thing we don't ask is that if you're not serious or you've just done this for, information purposes or information gathering, great. Tell friends, family, whoever. But if you also want to talk to somebody about maybe a traffic ticket or a family law matter or something, we're probably not where you need to be. Other attorneys and stuff in town do those types of things. So without further ado, I'll take any questions at this point in time. Let's see if we have one here. Okay, see somebody asked about the joint real estate titling with children. The problem with that is, well, let me start with the positive. Yes, having your property titled jointly with children will get around probate. However, again, if you have a falling out with one of those children before you pass away, that house is, or that a cash account or whatever kind of joint asset it is, they have access to that just as much as you do. They could clean out that account, or they could, you can't kick them out of the house you've made them a joint owner on. They just have as many rights to you. And I've seen a lot of situations like that go south. So for many reasons, we try not to do that if we don't have to. Okay. Any other questions? Okay. Without seeing any, I appreciate your time and we hope to see you in the office. But otherwise, I hope you have a wonderful remainder of your week. We'll see you soon. Thank you so much for your attention.